And this is really just an important part of Washington's laws that I want to make sure that if you are a Washington resident and if you are a married couple or in a partnership, a domestic registered partnership, that you understand that Washington will not honor revocable living trusts to set up an asset protection trust against long-term care costs for your surviving spouse. So I know that was a lot of words, so let me explain it again. So in Washington state, let's say you are a couple, you're married, and you are concerned that you want to make sure that you don't leave your spouse in a situation where your spouse will have no money when you're gone. And this is the key, you're concerned about long-term care costs. And frankly, long-term care costs can be huge. I mean, $10,000, $12,000, $16,000 a month. And you are concerned that when you're gone, your spouse will need long-term care. Perhaps your spouse has a diagnosis already of Alzheimer's or Parkinson's. There's all sorts of diagnoses that come, particularly as people age. And you're very worried all your money will be spent on long-term care costs. And that's a very common concern, very common. So let's take a situation where a couple has $1 million or $2 million. It doesn't matter. What I'm talking about is, well, it does matter. If you've got tens of millions of dollars, you're not concerned about running out of money. You're concerned about taxes. But if you are the majority of people who don't have a big taxable estate, you've got $1 million or a couple of million or whatever it is, you want to make sure you leave a nest egg for your spouse when you're gone. In Washington state, how we accomplish that is through a will that contains an asset protection supplemental needs trust. So for ease of math, I'm going to take a husband and wife and they've got $2 million. Let's say they have a very nice house worth $1 million and they've got $1 million in investment accounts. And one or both of them is frail or has a cognitive diagnosis. So let's say the husband is frail, the wife has Alzheimer's, husband dies first. His half of this $2 million estate, or $1 million, because a half of two is 1 million, will go through his will through the probate process into an asset protection trust his will creates through the probate process for the benefit of his wife, who has Alzheimer's. So what we would likely do in that scenario is we would take the $1 million of investments and put it into the trust for the surviving spouse. Then the surviving spouse has cognitive issues. She has Alzheimer's. She can't live alone anymore. That $1 million that is in this trust is not going to count against her for Medicaid eligibility. So there will be a trustee of this trust, obviously not the surviving spouse. And if the circumstances and the care were right, that trustee could apply for Medicaid right now for that surviving spouse. The $1 million in the trust does not count against Medicaid eligibility. The $1 million house does not interfere with Medicaid eligibility. So this surviving spouse could be on Medicaid immediately right away. That is the benefit of having a will with this asset protection supplemental needs trust. You cannot get that result through having a revocable living trust in Washington. Only through a will, through a probate, can we accomplish that $1 million protection.